This program is brought to you by Emory University.
All right, good afternoon, everybody. My name is Matthew Cavadon. I'm the current director of the Emory Law School Supreme Court Advocacy Program. We'd like to welcome all of you here today, and thank you very much for turning out to discuss the current Supreme Court term. And we hope that you enjoyed the snacks and beverages that were provided beforehand. As you may have noticed, there will be more to come following our conclusion this evening. So for those of you who are perhaps not as familiar with what we do, or who maybe have heard our acronym but haven't seen a whole lot of our work, we are the only law student-run organization that regularly files cert petitions and amicus briefs at the U.S. Supreme Court. That means that our members are researching, writing, and ultimately filing briefs that either try to convince the court to take cases or that represent the views of people who otherwise wouldn't have their voices heard at the Supreme Court. Right now, this year alone, we've worked on about a half a dozen cases. We have somewhere around 36 students at the school who are researching and writing for us. If you have not been involved and would like to be in the future, please do come up to our table afterwards and let us know. We have an email list and we're regularly recruiting for cases. We will probably have 1 or 2 more this year before the semester lets out. Our cases this year alone have ranged everything from diesel tax discrimination preemption to police use of force. We've actually had 2 cases where we've worked both at the cert stage, and then when a case is granted cert, we've worked at the merits stage as well. That's the Amtrak case that some of you may have heard about, or if you haven't yet, you probably will very soon. And the Sheehan case, which involves police application of disability discrimination policies. So we're very excited about that. I'm going to turn things over now to Professor Shalf, our faculty advisor. She will introduce our 3 panelists, each of whom has quite a bit to offer this evening. And then we'll open it up. We will have a couple of different topics that we go through. We're hoping to have some interactivity as well. So please don't be shy. We do have a great student group here, and this is certainly a very friendly setting, I think, as well, not being inside of the auditorium. Let's make the most of it. So thank you very much for coming out again, and without further ado, Professor Shelf.
Welcome, and I'd like to welcome Tom Byrne, who has a special place in our hearts, as he was our lead counsel with Supreme Court Advocacy Program in the case in which we had cert granted and argued. He argued it and won 9-0, so that was wonderful. Thank you so much for coming. And this is fun for me because I actually don't get to sit down and sort of study what's going on in the Supreme Court as much as I study the individual cases we're working on. And so today is a great day to get to sort of step back and look at what's going on in the court. And as our panelists today, we have our dean, of course, Robert Shapiro, Professor Sasha Volokh, who is over on the far side there, and then in between, we have Professor Eric Segall from Georgia State University. Dean Shapiro became interim dean of the law school in 2011 and the dean in 2012. He has a bachelor's degree from Yale, a master's from Stanford, and his JD is also from Yale. He was editor-in-chief of the Yale Law Review and clerked for Pierre Lavelle on the Southern District of New York before he then clerked for Justice John Paul Stevens. He entered the academy after a few years doing litigation at Sidley Austin. And his teaching and scholarship interests are Civ Pro and Con Law, and Fed Courts and Federalism. And I'll let him go into more detail about his particular interests when we have the panelists sort of introduce their own interests. I'll go with Professor Segall next. He has a BA from Emory, actually, and a JD from Vanderbilt. He was the research editor of the Law Review there. He clerked for Judge Moy on the Northern District of Georgia and Judge Henderson in the 11th Circuit. Worked for Gibson Dunn and Department of Justice before he entered the academy. His teaching scholarship interests are Con Law and Fed Courts. He is the author of the book Supreme Myths, Why the Supreme Court is Not a Court and Its Justices Are Not Judges. And I'll let him tell you more about his thesis in that book. He appears regularly on an XM radio show, at least according to his bio. He's still appearing on that radio show. Stand up, talking about Supreme Court and constitutional law. And on a personal note, he actually was one of a few who mooted me in my first, in preparation for my first oral argument in the 11th Circuit. And then finally, we have Professor Sasha Volokh, bachelor's from UCLA, a JD and PhD in law and economics at Harvard, clerk for Kaczynski, and then for Justices O'Connor and Alito. He was awarded tenure just this past year, right? Yeah. And his teaching and scholarship interests are law and economics, administrative law, privatization, especially in prisons, and legal history. And he is also sometimes a client of the Supreme Court Advocacy Program. And in fact, I'm sure he will tell you about his experiences as a client in the Association of American Railroads case. So those are our panelists today, and I'm really just going to sort of guide the discussion a little bit. And so to start with, we are going to talk about sort of what you think the biggest or the most interesting cases are that have really caught your attention this year. But before you talk about the cases, why don't you give a little bit of perspective on where you're coming from? I know Professor Segall's perspective about sort of overarching, the role of the court, and I don't know if Professor Volokh or Dean Shapiro also have sort of a perspective they want to share before they talk about specific interesting cases. So, Dean Shapiro?
Sure. Well, thanks, Matt. Thanks very much, Sarah. Thanks for everybody being here. I don't think I've anything interesting here what Eric says and his overall perspective on the Supreme Court. I think in general, well, it'll be interesting to discussion about how much you think law has a role in the decisions of the United States Supreme Court. Look, in terms of big cases, there is the same-sex marriage case, which I think is going to be the Obergefell. We're deciding how we're going to pronounce that. Obergefell. Right. Obergefell case.
Same-sex marriage case.
The same-sex marriage cases, and I think that's going to be one of the most significant cases the United States Supreme Court has decided in its history. I think when your grandchildren are taking constitutional law at Emory Law School, they will be reading that case in their constitutional law books. It seems likely, I think, that the United States Supreme Court is going to find some kind of right to same-sex marriage. That was suggested, I think, the last time the Supreme Court dealt with the case. That suggestion was reinforced by their refusal to grant a stay in the recent litigation arising out of Alabama. So it'll be interesting to see. Of course, one can never say for sure, but I think that will be a very interesting case. And I'll just mention another one, which we're all focused on, I think, which is King versus Burwell, which has to do with the Affordable Care Act and the issue of statutory interpretation. And depending how the court decides that, it could mean that it's going to be very difficult for the Affordable Care Act to operate, I think, the way it was thought that it was going to operate. I also think it's a fascinating case because for those of you who've taken legislation regulation, right, shows that statutory interpretation really matters. It's a fascinating case of statutory interpretation. It involves issues of potential administrative deference. So I think that will be a very interesting case to see how the court goes. I think inevitably views for an ideological lens, although I think for people who take particular approaches to statutory interpretation seriously, one could easily come up with a decision to that independent of some of the other issues that are involved. And I'll just mention two other cases, two other issues which are coming up but haven't reached there yet. Abortion hasn't been in the Supreme Court in a long time. There's an abortion case coming out of the Fifth Circuit. It's in the Fifth Circuit that will eventually come out. One thing that's going on is a lot of laws being passed, targeted regulation of abortion providers, which is having a significant burden on the provision of abortion. And it'll be interesting to see what the Supreme Court thinks about the test that is laid out a long time ago as to whether there is a substantial burden on the right to an abortion and whether there remains, it seems likely that there are 5 justices currently on the court who are committed to the idea that there is a constitutional right to abortion, but the scope of that right is something the court may be coming back to before too long.
Thanks, well, thanks for having me. It's great to be here. Good afternoon. It's always a privilege to be with Dean Shapiro and Professor Volokh. There will be some disagreements, is my prediction, but we'll see. So my overarching thesis in my book that I spend a lot of time in history supporting in my book is that, in fact, the Supreme Court is not a court, and its justices are not judges in any meaningful sense of those terms. And to make a long story short, what I mean by that is they don't take prior law seriously at all. Not really. They take prior law very seriously when they write their opinions. But in cases they don't care about very much, they will sometimes not work very hard to agree with the result. But where they care, prior law doesn't matter. And I start with 1803, and I'm talking about liberal courts and conservative courts, Republicans and Democrats, it doesn't matter. In virtually every disputed case that's ever been in front of the Supreme Court, the law, so to speak, could go both ways. I'm not making an argument from discretion. It's not just they have discretion, it's that they don't care. And so I go through literally 30 or 40 cases, I could do hundreds, where their restatement of prior law is either demonstrably false or not relevant to the decision they made. And by the way, I'm not saying this is a bad thing. If I were on the Supreme Court with life tenure and I can't be fired, and I can do anything I want subject to the willingness of the American people to go along with it, and I was really invested in something, if I thought it was just the most horrific thing that the Congress and the President agreed to pass a health care law that makes people buy health insurance, and I thought that's going to be the downfall of our country because I'm a libertarian and I believe in federalism, then I would probably do what I think is best. I understand. The mandate was part of a law that regulated $1 trillion industry that affected every single state, and the justices most committed to text and history held that the mandate was beyond Congress's power, even though there is no anti-mandate provision in the text, and the earliest Congresses used mandates. There's nothing legal about the decision in NFIB about the mandate being beyond Congress's Commerce Clause power. But, as I say, if I felt that was awful, and I had the final say, would I let law trump my value judgment? Probably not. The last thing I'll say about that is, that's all you need to know about why Justices Ginsburg and Scalia disagreed about virtually every difficult constitutional law case. They're both really smart lawyers. They're both really good historians if they want to be really bad historians. They're equal historians, doesn't matter. The reason they disagree is because they're very different people off the bench. They have totally different life experiences, different family lives, different values. So Judge Posner says that constitutional law at the Supreme Court is about margaritas and cosmopolitans. You might like a cosmopolitan better than a margarita or vice versa, but you can't privilege that. It's taste, not logic. It all comes down to taste, not logic. That's my short. I can defend it better than that, but that's my short. Having said that, I do not have to engage in unilateral disarmament. So if we get into thick doctrinal discussions, I will compete at that level and pretend it matters. But I will tell you, in terms of generating results, it doesn't. I think the same-sex marriage cases are really important, obviously. They're done. They're done. There's no chance Justice Kennedy, absent some kind of mental, physical incapacity, is going to vote differently. Last night, Justice Thomas basically said it's done in his dissenting opinion in the Alabama case. So it is, in fact, done.
Could you elaborate on that?
Well, so Justice Thomas dissented from the court's decision not to stay the Alabama District Court decision that ruled Alabama's law unconstitutional. And in that dissenting opinion, he said, we should stay this. Perhaps the court is already, I'm paraphrasing, but he said, perhaps the court has already reached a decision, we should stay it anyway. He didn't say it quite that strongly, but he basically said that. Trust me, it's done. I think that the...
You could reach a decision before having read the briefs.
I know, imagine that. Justice Kennedy reached this decision 2 years ago when he voted to grant standing in the Prop 8 case, but was outvoted, interestingly, by 5 justices, including Justice Ginsburg, who made, and I've written about this 3 times now, twice for ACS. I point to Robert because he's involved in ACS. I didn't point this way for ACS. I understand. Justice Ginsburg went around the country prior to the Prop 8 case saying Roe versus Wade, no one's more pro-choice than Justice Ginsburg, but she thought it was a mistake because it decided everything in one fell swoop. She's right. The court made a great decision not to do this 2 years ago, and when it does it in June, the backlash will be much less. The other case I want to talk about before I let Professor Volokh go is I do think there's a major death penalty issue percolating. This is not my area, but I've studied up a little bit on it. I mean, it is inconceivable that we are killing people today without telling them how they're about to be, the lawyers, how they're about to be killed. This can't be something, I'm sorry, it can't be something civilized countries do. It just can't be. And that issue is going to, I mean, Oklahoma won't say, Georgia won't say, and couple that with the idea that there have been botched executions. I mean, empirically demonstrable botched executions where people have suffered for longer, I think the equivalent of torture, basically. So I'm not suggesting anything about the death penalty writ large, but in terms of the state not disclosing the chemical combinations in the shots they're giving these, that has to change. That comes down to Justice Kennedy, and that I have no prediction.
Okay, so what I think are, I'm going to talk about two cases that I think are interesting. They're definitely not the biggest cases of the year. The biggest cases of the year are King v. Burwell and gay marriage. And I'm sure we'll talk plenty about that. But here are two cases that I've been involved with. And one of the cases, I am the client of LSCAP, and the good students at LSCAP wrote a kick-ass brief, both at the cert stage and on the merits, an amicus brief. Oral argument has been held, and I'm waiting to see, whether we get cited. But
Or if you win, right? You're the client, right?
I'm the client, the amicus client.
Oh, okay.
And I'm an amicus of the court. Right? So, but anyway, the case is Association of American Railroads versus Department of Transportation, and I call this the Amtrak case. And basically, there's a statute which has a very interesting structure. Amtrak does all of this passenger traffic, and mostly the railroads have given up their duty to do passenger traffic to Amtrak. But they have to give Amtrak the right of way whenever they see an Amtrak train. They have to give it the right of way. Occasionally they don't, and then sometimes the Amtrak train ends up being late. So according to the statute, there are supposed to be developed performance measures so that you figure out the performance of trains, and if there's bad performance, then those performance measures are supposed to go into a determination of what kind of penalties the private railroads have to pay because of their failure to give the right of way and so on. Well, so far so good. What's interesting is that Amtrak itself has a role in figuring out what are those performance measures. So Amtrak and the Surface Transportation Board, or possibly the Federal Railway Association. Anyway, Amtrak and a government agency have to together agree on what are the performance measures that are going to be used to assess penalties on the private railroads. And this is kind of weird because Amtrak, even though it's kind of quasi-governmental, but at the same time, it is instructed to act as though it were a profit-maximizing corporation, and it's essentially, in some very important ways, in competition with those other railroads. And the idea that your competitor can participate in regulating you is something which kind of offends some notions of due process. Now, when this was at the D.C. Circuit, there was an opinion written by Judge Janice Rogers Brown, and that decision said that the problem was a non-delegation doctrine problem. That generally speaking, Congress can delegate power to the president, Congress can delegate power to all sorts of agencies, but she said Congress can never delegate power to a private actor, and there's a per se rule against delegation of power to a private actor. And in this case, then you have to decide that Amtrak is a private actor, and she sort of waved her hands and did decide that Amtrak is a private actor. And this is kind of, there's a tension there because Amtrak is a public actor for purposes of the First Amendment and various constitutional rights. Anyway, my view is that the D.C. Circuit got it right, but for the totally wrong reason. Because I don't think there's any rule against delegating to private actors, and so I think that the non-delegation part should be reversed. But I think that the statute does violate due process, and so my view is it should go back down to the D.C. Circuit so that they figure this out on due process grounds. So anyway, my argument, which LSCAP makes in this brief, is it's an interesting argument because it's one that's not raised by either of the sides. And so this is an argument, this is a case where LSCAP really makes an important contribution because it makes an argument which otherwise would not even be part of the debate, because generally speaking in our adversarial system, the only arguments that are considered are the ones brought up by the parties. So really for extra arguments, for unusual arguments, for arguments that are not in the interests of the parties to make, we rely on amici. And so, and that's where, kind of LSCAP and I come in. So that's Department of Railroads, Association of American Railroads versus Department of Transportation. That's one case that is interesting, that should be coming down soon. Another case, I signed on, I didn't participate in writing this amicus brief, but I did sign on to the amicus brief, and so did Tom Arthur on our faculty. It's an antitrust case, which is called North Carolina Board of Dental Examiners. And here, this is, the structure here, it's very similar to how dental profession, medical profession, lawyers, and so on are regulated in many places. It's basically a private group of dentists which regulates the dental profession. That is, you can't, in North Carolina, you can't practice dentistry unless you get a license from the Board of Dental Examiners. And the Board of Dental Examiners is composed of dentists, and now they're not gubernatorial appointees. They are elected by other dentists. So it's just, all you're doing is you're accountable to dentists. And of course, dentists want to protect their turf. And so when kind of discount teeth whiteners show up, the dentists hate discount teeth whiteners because they want everyone to come into the dentist's office and pay a dental visit fee for the teeth whitening. So they sent all these cease and desist letters to all these non-dentist teeth whiteners who set up in kiosks in malls and hounded them out of the state. If it was just private dentists that were doing this on their own, this would, very plausibly be an antitrust violation. But they say, no, we're actually a state agency. And when the state does the same thing, this is immune because state agencies have a state action immunity as long as they can show that what they're doing is authorized by the state, then that's okay. So really the question, there's a lot of complexity, but the bottom line question is, does this Board of Dental Examiners count as a state agency, or rather do they count as though they were private people? And does it matter whether they participate in the industry that they regulate? Does it matter whether, to what extent does it matter that they're specifically accountable to the dentists? Would it be okay if they were gubernatorial employees, or would that still be bad as long as they practice dentistry and compete with the teeth whiteners? So that's a case which, again, it's not the most important case, but it actually would clear up a moderately important issue of immunity to antitrust law. So that's another case that I've been involved with.
And it would have implications for other forms of regulation of
professions, potentially it would have implications
lawyers.
For lawyers.
And doctors. Yeah. And you see this...
Pharmacy boards also.
Yeah, right. And you see this in bars, state bar, like lawyer bars, not...
Not the fun kind of bar.
You see that there are a lot of issues, for instance, about real estate closings and other kinds of law-related professional services that don't involve, that some would argue don't involve the practice of law. And there is a sense of protectionism among the lawyers who are saying, no, doing a real estate, and this happened in Virginia when I lived there, no, doing a real estate closing is the practice of law, and therefore nobody except a lawyer can sit with you at a real estate closing. And so how much of that was motivated by the desire to protect consumers, and how much of it is motivated by a desire to make more people become lawyers and pay legal fees, as opposed to paying, paralegals or notarios or LegalZoom or whatever you might be paying. So that actually is can turn into a larger issue.
Yeah, and when I put on my econ PhD hat, I just recently worked as an expert witness in an antitrust case in the Eastern District of Virginia, where I was the witness on the side of a chiropractor in Alexandria who was being disciplined by the Virginia Board of Medicine because they were saying, all of the various things that you do, holistic medicine and so on, counts as the practice of medicine and not the practice of chiropractic, and so therefore we're yanking your license unless you agree not to do X, Y, and Z. Well, if she can't do X, Y, and Z, then she's out of a job. Basically we sued the Virginia Board of Medicine saying you guys are violating antitrust. So this sort of, industry self-licensing, very pervasive. I hate it. So I'm very glad to strike back against it, however I can.
So let's go back to the two cases that we mentioned. So we were talking beforehand about want to geek out a little bit. Just to demonstrate to the students who are here about how these issues about civil procedure and standing and all of those things actually do matter in these cases. It gets up to the Supreme Court, and you hear about the substantive issue, but you don't really think about, how do they get there? And so in King v. Burwell, Sasha raised an interesting issue that the standing is a little bit twisted, and I wonder if you would explain that, and then we can have disagreements.
Sure. Yeah, I don't think we'll be disagreeing on the standing part, but so basically the issue in King v. Burwell is, are tax credits available in Virginia? Because Virginia is one of these states that has not established an Obamacare exchange of its own. And if a state does not establish an exchange, the federal government establishes the exchange. And so everyone agrees that if there's a state exchange, then you get tax credits when you buy on those. And the issue in the case is, are those credits also available on federal exchanges? So this guy King in Virginia is saying, Virginia has a federal exchange, and therefore I and people like me should not be entitled to tax credits. Why would you argue that you should not be entitled to tax credits? And not only why would you argue it, but how can you have standing in federal court? Because to have standing in federal court, you have to have an injury. So in what way does it injure you to have extra tax credits? I had never thought of this until I was reading the briefs, and then when I found out the answer, I realized retrospectively that was a really interesting question that I should have been interested in. So suppose that King were saying, I desire to buy insurance. Then he'd be screwed. Because if you want to buy insurance, then of course tax credits help you because they make insurance cheaper for you. So there's no way you could show an injury. So instead what he said is, I want to not buy insurance. Because under Obamacare, if you don't buy insurance, it's the individual mandate. If you don't buy insurance, you have to pay a penalty. So I want to not buy insurance and therefore be subject to the penalty. Now, you might still be scratching your head. How does that help you? So how is the penalty calculated? It's the cost of the cheapest plan out there. So if you choose not to buy a plan, you still have to pay as a penalty the cost of the cheapest plan. And it's the net cost to you after subsidies. Now, you might still say, well, okay, fine, but if there are no subsidies, the cheapest plan is expensive, and so his penalty is expensive. And if there are subsidies, then his penalty is cheaper. So, but here's the thing. There's a special protection for poor people in Obamacare, which is that if your penalty is greater than 8% of your income, you're exempt from the penalty. So if there were no subsidies, his penalty would be super high. It would be above 8% of his income, and he'd be exempt from the whole penalty. But if there are subsidies, the penalty actually becomes quite reasonable and under 8% of his income, and he'd have to pay it. So this is this kind of ironic way that the availability of the subsidies, which decrease the price of insurance, actually harms him because of his very special posture of wanting to be subject to the penalty, plus this poor people protecting rule of being exempt, which you totally don't see coming unless you really know exactly how this penalty structure works. But in retrospect, it's genius.
I want to say two things about King versus Burwell for now, anyway. Actually, I want to say one thing about standing and one thing about King. What I'm going to say about standing is going to blow your mind, so I'm warning you ahead of time. In our country, in federal court, to have standing, you have to allege a personal injury caused by the defendant that can be redressed by the court. It's a non-negotiable constitutional rule that cannot be waived. It is subject matter jurisdiction, can be raised at any time in the proceeding. The foremost advocate of that requirement is Justice Scalia, without any doubt, both as an academic and as a Supreme Court justice. It is an anti-constitutional rule. It has nothing to do with text. It has nothing to do with history. It is made up in the heads of the justices, and I will show that to you. What the Constitution says in Article 3 is there has to be a case or controversy. And I absolutely agree that the Founding Fathers thought that advisory opinions wouldn't be allowed in federal court. That's absolutely clear. But if you have two adverse parties arguing about something real, let's take the ACLU and the government. And the ACLU has an ideological objection to something the government is doing. And the government wants to keep doing it. Will things change if the ACLU win? Yes, the law will change. Is there something real at stake? Yes. Are there two adverse parties? Yes. Has the ACLU been injured? Not necessarily. That personal injury. And here's how we know it's made up. In 1968, it may have been 69, an incredibly conservative law professor, who at the time thought Brown was wrongly decided, A true originalist, we have no more true originalists left. I wrote that essay yesterday, but it's true. There are no true originalists left. Volokh died, Mises quiet. He wrote an article that said in common law England, being a stranger to the court was always allowed. And the founding fathers had absolutely no notion of this idea that you had to be injured to be in front of a judge. You had to be adverse. Adversity, I think, is a fair constitutional requirement from case or controversy. Personal injury? No. It was made up in the justice's head, and if you really believed in text and history, you wouldn't apply it. So that's the first thing I want to say about standing. I agree with everything you said about this case. So I am in the deep weeds in the King case. I just wrote a piece for Penn Law Review. I'm going up 2 days before the argument to debate the lead lawyer for the other side. So we don't talk about this now, but for later, let me just say, in my 24 years as a law professor, and in writing, I won't go through my resume, but I've thought a lot about these issues. Cases in front of the Supreme Court. This is the most frivolous case I've ever seen, ever. And I've seen some frivolous cases. This is the most. If law mattered at all, the DC Circuit would never have held the way it did. A lone renegade district court judge out in the Midwest and in Oklahoma, I think, who had been sanctioned for partisan behavior, would never have ruled the way he did. Jonathan Adler, the law professor at Case Western, who is responsible for this case, has done a brilliant job of making the issues seem complex. They are not. They are incredibly easy. And if law matters, the plaintiffs will lose and the government will win. Whether law matters or not is a coin toss. It didn't matter in the Commerce Clause part of the last ACA case. I don't think it mattered very much in Hobby Lobby. Sasha definitely disagrees with that. But if
I disagree with you on Hobby Lobby and on King v. Burwell. So.
after we let the dean go, we should have that debate.
Thoughts on King v. Burwell?
Now I want to yield my time.
I'm happy to make the case. I mean, it takes 3 minutes, 2 minutes. Okay.
Four.
So this is easy. So this is easy. So I wrote an essay last week for a blog that took a very strong position. It was last Wednesday. Took a very strong position, which ironically that day reporters for the Washington Post, a lot of people took on the same day. We didn't talk to each other. The position is this. There's absolutely no evidence, not a scintilla of evidence, that the people in government who passed the Affordable Care Act ever thought for 1 second that subsidies wouldn't be available on all exchanges. And the reason for that is very, very easy to see. Everyone who discussed this law did so in the context of a three-legged stool. It's the way this law works, it's the way it was written, it was the way 4 dissenting justices in NFIB perceived the law, which is as follows. We want insurance companies to not turn you away for pre-existing conditions or charge you more for pre-existing conditions. Big part of the law. If they do that, it's going to cost them a lot more money. So we're going to make people buy insurance. We have to do that. If we make people buy insurance, that's going to be a very big drain on many, many poor people's budgets, so we're going to give them subsidies. 7 states prior to the ACA tried this in 6 without the subsidies. In 6 of those states, it was an unmitigated economic catastrophe. New York wasn't quite so bad, but pretty bad. It's how it worked in Massachusetts. Everybody knew the three-legged stool applied everywhere, and the plaintiff's suggestion that that wasn't true at the time has now been so repudiated in social media and in the briefs that I don't even think they're going to go with their narrative anymore. They're going to just stick with the text. Because their narrative was this was like a conditional spending statute, saying to the states, if you open up an exchange, we will give you the subsidies. That's their story. Now, I will be shocked if they make that story in front of the Supreme Court. It has been, no reasonable person can accept that story after the evidence of the last 2 weeks. Everybody they cited for that has repudiated it. There is no evidence. All right. What does the statute say? It's very easy. It's very easy. In the definitional section of when you can buy health insurance and get subsidies and all that, it says you get a subsidy if you buy insurance from an exchange established by the state. That sounds like they're right. You have to buy health insurance from an exchange established by the state. That's 1311. Except a later provision of the law says unambiguously, if the states don't create their own health insurance exchange, the Secretary of HHS shall create such exchange. Not a U.S. government exchange, Not a federal exchange, not a health exchange, but such exchange, referring to the 1311 exchange. There are numerous places in the law where if you don't have that interpretation, the law makes no sense at all. The biggest one being, there's a section of the law that says you have to be a resident of the state that established the exchange to buy health insurance. Think about that. You have to be a resident of the state that established the exchange to buy health insurance. Who is the federal exchange going to sell to, if not residents of that state? The only possible interpretation of that is state exchanges and federal exchanges are interchangeable for purposes of the three-legged stool. And everyone in America understood that to be the case. And here's the kicker, and this is why whatever Sasha's about to say, he's wrong. I don't have to be persuasive. I don't. I don't have to be clearly right. I am both persuasive and clearly right. I don't have to. I only have to be reasonable. All that has to be is reasonable. Because this is, and I'll yield in 1 minute. The Secretary of the Treasury looked at the law, the context, it's a 1,000-page law, all the various implications, and said, do I have the authority to give subsidies to people who buy health insurance on federal exchanges? If the law is ambiguous, that interpretation only has to be reasonable. That's a Hornbook law. That's Chevron. It only has to be reasonable. 1321 makes it a reasonable interpretation. I think it makes it the only interpretation. But at worst, it makes it a reasonable interpretation.
All right. So I guess I have to argue that your interpretation is both wrong and unreasonable, which I will do. So the first thing I want to say is, I've read the briefs, and it really helps. In all administrative law cases that involve big statutory schemes, maybe many of you have never heard of Section 1311, 1321, and so on. Really, I think we would all agree, it would be very helpful if you had the statute in front of you and we could actually walk you through it, and we have a very short amount of time. So what I will tell you is that you will really benefit by reading the briefs, and I encourage you to do so. So nonetheless, and I don't have the statutory sections, all of them at hand. So I'll just refer to some things that are mentioned in the briefs. So the main point about the statute is, as Eric said, that the part we're arguing about says that you get subsidies if you are buying from an exchange that was established by the state under Section 1311. So there's one section, 1311, which talks about state-established exchanges. Now there's another section, 1321, which talks about U.S. government-established exchanges. And so it says that if a state doesn't establish an exchange under 1311, then the U.S. government shall establish such exchange. So, now, such exchange, that's an issue which I'm going to get to. So Eric says that such exchange means that it's an identical exchange. But the basic thing in my mind is that if a state establishes as an exchange, then it's an exchange established by the state under Section 1311. If the federal government establishes an exchange, it's an exchange established by the federal government under 1321. So you cannot describe such an exchange as an exchange established by the state under Section 1311, because it's neither established by the state nor is it established under Section 1311. So at that basic level, I think that the text is crystal clear. And when the text is crystal clear, there's no room for an ambiguity that would bring in Chevron deference. The plaintiffs also argue that Chevron deference is inappropriate because here we're talking about Chevron deference to the IRS as administrator of the tax credits, and that should yield to a particular canon about clear statements for tax incentives. But we don't need to get into that. But I would just say that we don't even get to Chevron deference because you need an ambiguity for Chevron deference, and I say that the language is clear. And when the language is clear, really the way that you get around clear language is so-called absurdity. And now absurdity, in the absurdity doctrine, that doesn't just mean you get a statute that doesn't work as well, or even that you don't get you get a statute which would be a failure. It's got to be that the absurdity doctrine is on the order of a scrivener's error. that it's something where the statute makes, like such no sense that there's no rational person anywhere who would ever adopt it. And I think that there are various reasons why somebody would adopt it. Now, before I get to that, there's the question of what does it mean to say that the federal government shall establish such exchange? Because that's one argument, is that when 1321 says the federal government shall establish such exchange, then that basically kind of incorporates that it's a state exchange under 1311. But another meaning of such is just the federal government shall establish an exchange that is like that. So it just means if the states don't establish their state exchange under 1311, the federal government shall establish an exchange that is like that under Section 1321. That's not enough to make that as an exchange established by the state under 1311, because it's neither by the state nor under 1311. Now, in the plaintiff's brief, and I can't go into all the details, but they just point to a lot of places where it has been claimed that the statute makes no sense, but they show that there is kind of another reading, which I find a not bad reading, which shows that actually the statute still makes sense, not enough no sense to be absurd. It's something where you can say a rational Congress could have adopted that. In particular, even if you don't think that anybody was thinking about this, the argument is that the reason why Congress might have wanted subsidies to be available on state exchanges and not federal is they wanted to establish an incentive for the state to adopt its exchange. That is, you should adopt an exchange and then your citizens will get all these tax credits. And if you choose not to, we'll establish one, but then your citizens will be harmed. So it's to the benefit of you and your citizens to establish your own exchange. And so essentially the argument is that Congress would have established a kind of penalty default. And they thought that the penalty default would be so unattractive that the states would all establish their exchanges. Then it turns out 36 states did not establish their exchanges. Whoops, Congress was wrong. That does not mean that it was irrational to establish that penalty default. Even if it means that the statute doesn't work well and that the exchanges kind of collapse, that sometimes penalty defaults, even very unattractive penalty defaults, are what you could rationally choose to do, and then sometimes you bet wrong. But even if it turns out that no legislator actually thought that, that's not important unless you are a very strong advocate of legislative history, which I'm not. I think that when the statute is clear and the reading is, even if suboptimal, not absurd, then you go with the text and you don't look at legislative history. But in any event, there are at least various places, and again, look at the plaintiff's brief and they will point to a couple places. One of it is the couple of videos of Jonathan Gruber, who is not one of the legislators, but he was a person who was involved and he made this claim. And there were a couple cases where there were some legislators who made the claim, and I don't have the brief on me and I wouldn't cite pages to you, but you should look at the brief. And they actually do talk about how there is at least a little bit of legislative history in support of that, though I don't think it's necessary. So that's my bottom line thing. I think that the text is clear. The claimed absurdities, once you look into them, are not all that absurd, and really that's what you need, and you don't even get to the point where you're looking for deference.
I'll be two very quick. Go ahead. I'll wait till you. No, okay. There are two things that aren't true. There are just two things that aren't true. Sorry. First of all, there is no rule in the 1,000-page law of the Affordable Care Act, anyplace, that says there will be no subsidies on federal exchanges or only state exchanges get subsidies. Where the established by a state subsidy rule comes from is buried in a definitional section of who qualifies for subsidies. It's a qualification part of the law. That's all it says. That's really important because under South Dakota versus Dole, under NFIB, the last Affordable Care Act case, Congress can only condition money in that kind of, take this money and we'll give you X, Y, and Z. If you don't get the money, you lose X, Y, and Z. If the condition is clear, you can't argue with that.
It turns out that I just taught NFIB and South
Wait a minute. Okay, well, the court struck down the Medicaid part of the original Affordable Care Act under the spending power conditions threats doctrine because in the statute it said to the states, if you don't expand your Medicaid coverage, you will lose all your Medicaid money. That's a threat. If you, the states, don't, there's nothing like that in this law. Nowhere, no place, no how. And in fact, the way you interpret it makes it unconstitutional. And almost everybody agrees with that. Even Jonathan Adler has sympathy, the big lawyer on the side, has sympathy for that point, which is this kind of threat, under the table, below the surface, without clear conditions, is unconstitutional under South Dakota versus Dole, much less NYU.
I don't think South Dakota versus Dole applies here because it's not conditional spending to the states. It's the denial of a benefit to individuals on their personal tax return.
Well, let me just move on a moment from our symposium on King versus Burwell. But just, I find this fascinating for a slightly broader point. I think that certainly 30 years ago, certainly 40 years ago, this would be viewed entirely differently in the law. Question B, what was Congress trying to do? I think the answer to that is pretty clear. Congress was trying to establish a way of giving subsidies, and the fact that it's hard to get there through the text, or it's complicated to get through the text, really wouldn't be especially relevant. I think we really see the impact of textualism as embodied in a lot of people, including particularly Justice Scalia, and that you get a sense of what's at stake in a decision about textualism versus other modes of statutory interpretation, of whether you think that's the way a government should be deciding what a statute means. That is, if it stays the case. The interesting question is, did Congress clearly intend there to be subsidies? What we can do about what that means for when there are exchanges established by the federal government. And it is that we don't care, but because of the way the statute's written, we may reach a result which nobody thought we'd reach. I mean, that's where textualism can drive you to, and there's a theory of why you would want that, but you get a sense of what's at stake in adopting a kind of textualist point of view, where questions of complex governance come down to these issues about how we're going to parse these sections together, as opposed to a discussion about what was the legislature trying to do when they were legislating this very complex area.
Boy, I disagree with that. You may say, how? Boy, I disagree with that. Justice Scalia, 2 years ago, or 3 years ago, someone correct me, the court had a case about tobacco, and whether the FDA, I think it was, could regulate tobacco. The issue was tobacco a drug? 15 years ago, thank you. Tobacco is a drug. Is tobacco a drug? Is tobacco a drug? Is tobacco a drug?
Under the Food, Drug, and Cosmetic Act, I think yes. And
What did the court hold?
I agree with you that Scalia had a totally indefensible opinion in Brown and Williamson, where he abandoned his textualism, and I blame him.
So the reason I disagree with Dean Shapiro is, I can't say it this way, and I really apologize. The naive and quaint view that the method of interpretation is going to make a difference in highly charged political cases. It doesn't. It doesn't matter whether you're a textualist or believe in purpose. Thank you. That it doesn't. It doesn't matter. Which is why Scalia is going to vote against the government in this case, whereas he voted against the government in the Brown and Williamson case, and those are inconsistent.
Right, well, and that is something we disagree is. I do think that ideology makes arguments, a question of whether off the wall or on the wall, and there are arguments, I think, that 40 years ago, I don't think anybody would seriously have entertained the argument that the plaintiffs are making here, and you have a bunch of people who claim to be serious doing it. So I think it would be extremely difficult for anybody, whatever their political views, to adopt that argument 40 years ago, whereas now it's much easier.
And in fact, the same was said about the Affordable Care Act case, the Commerce Clause case, that 30 years ago, it would have been, well, of course, this is within the commerce power, and then that it was an issue was surprising to most, certainly to most scholars.
Not to me.
Not to you.
And this probably supports your own point, which is the ability of ideological bloggers to create a discourse under which certain arguments thought to be previously off the wall are now on the wall is a sign of how there's no law going on. Am I right there?
Yes, and I have a theory that
agree.
this was the chain of reaction. I can't prove this, obviously.
The Volokh conspiracy.
The Volokh conspiracy and Randy Barnett particularly worked incredibly hard to say if you have to buy health insurance, you have to buy broccoli. And of course, we all think the government making us buy broccoli is incredibly offensive, which led, I think, Judge Hall, in the 11th Circuit, to ask the government's lawyer, give me a limiting principles. I don't think she wanted to be happy. I don't think she minded having to buy health insurance. I'm sure she minded having to buy broccoli. The government gave a ridiculously horrible, pathetic answer, at which case I wrote a blog saying the government's going to lose. They lost the 11th Circuit, created a circuit split without the Volokh conspiracy and Randy Barnett working hard to make you afraid the government was going to make you buy broccoli. That case comes out there.
I agree with that.
See you tomorrow. I'm going home.
So now that we've taken that case apart, I just wanted to geek out one additional step here with the Alabama case. because we're talking about this earlier. So there's an interesting issue there in how they, in the effect after a decision is made in the district court, now we're talking about, because there hasn't been a decision from the Supreme Court, the impact of a district court decision that a state law is unconstitutional and whether that actually leads directly to marriage licenses issuing. I don't know, Dean, if you, since you haven't had a chance to say a whole lot.
Well, there's just the issue, there was, as often the case, when there was a challenge to the Alabama statute, the Alabama Constitution, which banned same-sex marriage. The suit was brought against the Attorney General, and there was an injunction issued by a federal court against the Attorney General of Alabama saying you may not enforce this law because it violates the federal Constitution. Granted a stay, but then the stay expired and was not granted by the 11th Circuit or by the United States Supreme Court. The question is, so if you're a probate judge in Alabama, are you required to issue a marriage license to a same-sex couple? And one argument would be, well, but the federal court issued an injunction, but here it would seem to be significant to whom the injunction was issued. And in fact, when one of the probate judges refused to issue the marriage license, the plaintiffs went back to the original federal court judge and said, you should hold that judge in contempt. And the federal judge said no, because that probate judge was not a party to the original lawsuit, so the person cannot be held in contempt.
And I would go even further, which is I think that the federal district court, and you guys are more courts people than I, but I think.
Oh, are you teaching it?
No, but federal district court, the state courts do not have to listen to the federal district court. The federal district court says, the Alabama statute preventing gay marriage is unconstitutional. The state courts can keep doing whatever they like because the federal district court has no appellate authority over the state courts. It's only there's an injunction against the attorney general, but the attorney general does not control the state courts.
I think that's 98% right, but I do think there's one situation where a federal court can enjoin a state. I know there is a state court, which is when a case is resolved by the federal district court, the losing party goes to state court to relitigate that case. Under the Anti-Injunction Act, the district court then can enjoin, assuming it passes abstention doctrines, can enjoin state court.
Okay, well, and that doesn't arise here.
No, and it's also an issue though is whether they're really acting, it gets more complicated too, whether these state probate judges are actually acting as judges. Right. I mean, when you issue a marriage license, basically it seems to be an administrative authority rather than acting as the judicial authority. So you could be subject to an injunction perhaps, though they weren't.
Right. So in this, like Georgia, actually, Alabama's statute just says there's the marriages between a man and a woman, and no marriage license shall issue for a same-sex couple. And then the other is that marriages from other states will not be recognized. So that statute has been found unconstitutional, and the injunction is against the AG for enforcing the statute and the constitutional provision. But it does not say, and marriage licenses shall issue. It's up to the state court system and the probate system, and however Alabama state law works. What I would say is you have to actually institute a mandamus action against the probate court, and then you would have to carry that up, and that would be in state court. So you would have some kind of mandamus action saying that the probate judge should have issued this and did not, and then they would have to raise the defense that there's a statute yet.
Okay, so you're saying that federal courts held the Alabama law unconstitutional doesn't necessarily grant them the authority or compel them to do that.
Right. So there was an obstacle to them issuing marriage licenses. So they were authorized, the probate judges were authorized to not issue marriage licenses because the law prohibited them from doing so. That obstacle has been removed, but the probate judge, now there could be Alabama law that requires a probate judge under certain circumstances if you meet the requirements.
Or God's law.
Or,
that's what Judge Moore said.
That's what Roy Moore says.
I also suspect that Roy Moore does not have the authority under Alabama law to compel the probate judges to do anything.
Right.
There's a lot I don't know about Alabama law. but it's sort of consistent with what we know about Roy Moore, and he probably does not have legal.
That's why he took it from God.
Yes.
This is the Chief Justice of Alabama.
Yes.
Well, I don't know if there's been a separate litigation before Justice Roy Moore, but can he even come out and say, well, this is wrong?
He might have supervisory, we don't know.
Yeah, we would have
He
to
might
know.
have supervisory authority.
I would suspect that any supervisory authority over the Alabama courts has to be exercised by the Alabama Supreme Court as a whole,
Yes.
not by Roy Moore himself. Like, if I'm a federal district judge and John Roberts tells me to do something, I can safely ignore that.
Right. So, I mean, and Roy Moore has a history of being outspoken about various kinds of issues that he has, like, no authority to actually speak on behalf of the court. And that's how he ended up, he was impeached?
He was
Already
removed, he was removed by some special
Or
Alabama commission or something
Yes.
like that for refusing to obey the injunction to remove the Ten Commandments.
For refusing to obey the 11th Circuit. And actually, you know, the...
God's law.
Yeah.
But they reelected.
But they reelected him, so, you know, it's a crazy world in Alabama. It's sort of like Virginia, they're doing the same thing with one of their legislators. But, yeah, so it ends up being this complicated issue of state law to actually enforce it because there's nothing forcing anybody to issue marriage licenses. Now, apparently marriage licenses are issuing from other probate courts, but just not this one in particular. The other interesting fact is that at least the couple in the first case in the Alabama court, they were actually already married in California. And they were actually trying to travel under an adoption statute that allows one spouse, somebody to adopt their spouse's child, and makes it easier to do that than a regular adoption proceeding. And so, again, arguably, that finding this statute unconstitutional should instantly allow the probate judge to recognize the California marriage, and then they can proceed under this adoption statute. But again, if the probate judge refuses to recognize the marriage from California, then we're back in the same place. So this couple should not have to get remarried in Alabama. It's just that they're trying to get their marriage from California recognized. There is another couple, though, that has not been married in any state. And based on the first decision, the district court also ruled that based on that, they should be able to get married.
Actually, I'm wondering if maybe Robert or Eric, whether you have any view on what the strategy was in this case. And so, like Sarah said, the plaintiff, Searcy, was not trying to get married because she and her partner were already married in California. She was just trying to adopt her partner's child under the statute that makes it easier to adopt your spouse's child. And obviously they said, well, that's not your spouse. So she lost. And then they appealed that to the Alabama Circuit Court and lost there. At that point, they could have just appealed directly to the U.S. Supreme Court. There's no reason why they couldn't have appealed directly to the U.S. Supreme Court and raised the same argument against the statute. But instead, she went to federal district court and sued the Attorney General, raising the argument against the whole statute, and got an injunction against the Attorney General. And I'm wondering if you guys have any view on why that was a sensible strategy or what was going on there.
When was it? Do you know? How long ago was it that the Alabama highest court ruled against her?
Yeah, I don't know.
But that's a big fact, I think, because all kinds of litigation all of these cases are being brought, most of them, in conjunction with people who are coordinating this litigation nationwide. And it's hard to know exactly what's going on, but they may have wanted to wait a little bit longer until more federal courts had struck down same-sex marriage laws, which would have been my advice had I been asked.
Yeah, and it could have been, just timing.
Yeah.
The Supreme Court had already denied cert in one case, and they maybe thought that the best bet was to travel and get to the 11th Circuit to say something about it, rather than trying to go this way.
Can I say one really quick thing before we run out of time? I really want to say this to somebody.
You can talk to us.
Thank you. I've been really involved recently in transparency issues at the Supreme Court, and there are two particular ones. One is going to change, one is not. That should offend everybody in this room. One is the camera issue. It is absolutely insane that we don't watch, we're not going to be able to see. Justice Kennedy on June 29th or 8th is going to issue a landmark, historic, civil rights decision that no American will ever be able to see again. So I can't show him Brown, I can't show Roe, I can't show Citizens United if that floats your boat. But the idea that today, this decision, this moment, and Kennedy's going to do something dramatic and talk about the mysteries of life and that kind of thing. It's lost to history forever. Forever.
You know, there's an app where you can take the video and you put it on Talking Dogs.
I do know that. And that will happen.
Because you do have the audio.
But there are now numerous public interest organizations devoted to this issue. Fixed SCOTUS, Open SCOTUS, you name it. Get involved with that, because it is, your children should be able to see this decision. They just should, and they're not going to be able to. Second, really quick, I'm talking about abortion. Earlier this year, the Supreme Court doesn't tell us who votes what on cert cases, who voted to grant, who voted to deny, and doesn't tell us a lot about emergency stay motions, and they're all secret. Whether to hear or not hear a case is one of the most important things Supreme Court justices do. It is a public event-type decision. We should know how they vote. We should know, did you vote to hear the case? Did you vote not to hear the case? I even will accept they didn't vote at all because 4 justices already voted to hear the case. I don't care. But the idea that that's secret?
How about conference deliberation?
No. I work for the Department of Justice. I defended agencies all the time and said, you don't get to see our deliberations. You get to see our final decision. The decisions on cert are final decisions. They're not deliberative.
And by the way, you do get, I mean, it's funny now, you can see that when the justices release their papers many years later, so you put the Blackman archives online, so if you ever want to see what cert petitions look like, what conference records look like, you can go and
if they make their papers public.
Right.
Suitor, 50 years.
And the interesting thing about cameras in the courtroom and all the theories about why they shouldn't be there and that sort of thing is the Georgia Supreme Court and the Court of Appeals for a number of years now stream their, at least I know Georgia Supreme Court does this for all their arguments, they stream them live.
England, Canada, more than half the states show up on TV. England, Canada, more than half.
And I think it's educational for the general public, right? So that's something that you could get involved in, and that it doesn't seem like that huge a step. I can understand maybe the voting, because you might misinterpret the votes.
We don't keep public decisions secret from the public because they could be misinterpreted. We don't.
So let's talk about some other trends or cases coming up that, well, actually, we haven't talked about cases that have been decided already this term. Are there cases that have been decided already this term that you think are surprising in some way, different from how you would have expected them to come out?
Well, one thing you should all recognize is that it's February, and so they only started releasing opinions in something like January. So there have been about 20 opinions released so far, and like half of them are summary reversals of the Ninth Circuit or whatever. I mean, they're interesting ones. They're interesting, but they're not ones where cert was granted in oral argument. So they're general. So they generally tend to be of lesser interest. Not always, but they generally tend to be of lesser interest. So whatever's a big blockbuster case is going to be, even if it was argued in October, we're not going to see it for another month or two. And obviously the big stuff is going to come down in June. So that means that at this point, there's not that much which is all that exciting. The one case, Hyen v. North Carolina, was about when a cop searches you based on a reasonable mistake of law. And the court said that if that happens, then it's a reasonable search. So that's something which potentially can have profound effects because, well, you know, for example, it might be very easy for a cop to claim that he made a reasonable mistake of law. I mean, there is a limit, which is that a court has to find that that mistake was reasonable, but it's something that could still have a profound effect. So that's a case of some interest. There's Holt v. Hobbs, which is the religious liberty case about the Muslim inmate with the half-inch beard. And there was United States v. California, the 112-page opinion about the border between California coastal lands and the federal continental shelf, which is 112 pages long, and 109 pages of that is geographic coordinates.
In October, the court did something really significant. We didn't hear about it because it was like anonymous, but the court stayed a Texas law regulating abortion. I won't go into the facts. What was significant about it was Scalia and Thomas and Alito dissented from the stay of the Texas law that made clinics do all kinds of things they shouldn't have to do. But Roberts and Kennedy did not join their dissent, which may or may not, because we don't know how they voted because they don't tell us, but it may suggest that Roberts and Kennedy might be a little more sympathetic to the, or hostile to the Texas law than we think they might otherwise be, but that's just guesswork.
I just want to say, Holt versus Hobbs, Saj just mentioned the religious liberty case. I did mention it was a 9-0 decision. I mean, in favor of a Muslim prison inmate. It does have an interesting theme about religious liberty, picking up a little bit like what everyone thinks about the Hobby Lobby case about relating to the Affordable Care Act. It does seem that religious liberty is a theme of this court, and it does seem to be where social conservatism and economic conservatism comes together, kind of libertarian view about preventing the government from doing some kinds of things. It's interesting to see that kind of coalescence about different conservative views on that issue, and that is likely to remain a theme of the court.
Any other themes that you can see, cases that they tend to be granting or interested in?
You know, something people have commented on, which I think is true, we talk about kind of an anti-regulatory theme in a way with this court. That had been what people had thought about the Supreme Court, perhaps less interested in perhaps some of the social conservative issues, more interested in business kinds of issues, and I think there's been some truth to that. Again, there's some statistic people look at is, in general, when you have repeat players before the Supreme Court, you see who are the winners. Over time, the United States tends to be the big winner. They do very well. They can often choose what cases they pick. The Supreme Court gives them a certain amount of deference. They often are on the criminal cases, which the Supreme Court in general have been pretty sympathetic to the government on. More recently, though, the repeat litigant that has won more than the United States has been the United States Chamber of Commerce.
Who has not yet filed a brief supporting the plaintiffs in King, which makes me think that the plaintiffs might actually lose.
Since there may be also some instinct in wanting to keep their winning record.
A really interesting dynamic, I think, that we don't know about is, because we don't see the votes, is my guess is on really controversial cases, if the four moderates think they have Kennedy, they'll vote to grant cert, and if they don't, they won't. If the four conservatives think they're going to win, will have a chance of winning, then they'll vote to grant cert. If they think they have Kennedy, if they don't, they might be afraid to. I don't know if that's true, but I think it's a reasonable guess.
Note the rhetorical thing where Eric calls the conservatives conservatives and the liberals moderates.
Justice Breyer voted in Grutter and Gratz the way the conservatives did. He has done many, many conservative things over the years. I will defend to my dying day he's a moderate.
Well, in fact, what about voting patterns as between justices? Have we seen anything unusual, or are we seeing the usual patterns emerge?
Harvard Law Review's got their statistics every year, well, and Scotus Block too, where you can see the percentage agreement among justices, but I haven't consulted.
Yeah, there's a misleading thing about unanimity, because last year there were more technically unanimous cases, but they weren't, because in most of the high-profile cases that were unanimous, there were clear doctrinal differences. That's one thing. The second thing is the 9-0 vote in the Muslim inmate case I predicted last year. It was obvious the court was going to take a case like that after Hobby Lobby to show it's not just Christians we protect Muslims too. And there was no better vehicle for that in this case, because Arkansas didn't have any reasonable reasons for their rule.
My friend Hannah Smith, who is my fellow Leo clerk, is the general counsel of the Beckett Fund, which does a lot of this religious liberty litigation, and they litigated Hobby Lobby, and then they also litigated Volokh Hobbs.
Sure.
I remember it was very clearly established in the 11th Circuit that you couldn't have a beard. So that was like the one thing the prisoners could not have was a beard.
Well, but that wasn't the rule. That rule might have flown. I don't know. It wasn't. You couldn't have any beards at all. There were exceptions and things.
Okay.
It was a different rule.
All right. And any exciting prediction? I think we had a prediction on. We've had predictions on the King v. Burwell.
No, no. I don't know what's going to
predictions?
happen. I will say this: the single most important factor in the case. And the Wall Street Journal has started reporting on this last couple of days, is whether Justice Roberts wants to put the Republican Party in a completely untenable position. Because if the plaintiffs win, 6 to 10 million people lose their health insurance. They're not going to be happy. The Republican Congress can't fix it because they've been fighting Obamacare now for since 2010, and it gives the Republicans a real problem. So what you're seeing as late as recently as today are articles in the Wall Street Journal claiming the plaintiffs don't have standing. I think the Republicans are walking away from this case. The biggest issue is whether Justice Roberts wants to put the Republican Party in that position. And that has nothing to do with law at all.
I'm going to go out on a limb and say the government wins in King v. Burwell. I'm not saying I'm not very good at predicting. I'm probably very bad at predicting. So.
And there's the other standing issue, which you haven't talked about whether the people are eligible for veterans benefits, not just for everybody. They're trying to find other reasons why maybe there's no standing to maybe allow them to duck the case.
Yeah. All right. Any final thoughts on October term 2020?
Oh, wait a second. Gay marriage. Gay marriage was divided into two questions. One which is whether there's
Yeah.
an overall right, the other whether there's a right to the cross-state recognition. Do you guys have any views on whether there's kind of a split judgment on that or something?
Yeah, no chance. Almost no chance. And the game has to be played, but Justice Kennedy is not going to do anything other than a full throttle. You have a right to get married if you're gay.
And when Justice Kennedy writes his opinion, is it going to be a kind of comprehensible heightened scrutiny for gays, or is it going to be one of those totally incoherent things like Romer and Windsor?
Yeah, I mean, for the record, no one's more critical of Roma than I am. I think it's a decision that violates the rule of law. No, I do.
Right, because-
Not more critical than I am.
Because I've written that. And just take 20 seconds. Justice Scalia in dissent and the plaintiffs relied on Bowers versus Hardwick, which was still good law at the time. We can argue about it, but it was the case they relied on. It was not mentioned once in the majority opinion. Not one time. The lawyer went to his client and said, the state of Colorado, we're going to win because of Bowers. Argued we're going to win because of Bowers. Not one syllable in the majority opinion about it. What's worse than that?
It is interesting. I hope you're following constitutional law. I mean, there was the Supreme Court decided the Bowers case out of Georgia, which said that you could criminalize homosexual sexual conduct. Then Justice Kennedy wrote an opinion in the Romer case, which seemed inconsistent with that, though not overruling it, not stating a clear standard review. Justice Scalia said, look, why don't you just say if you're going to overrule Bowers? And so then the court took the large fish Texas and overruled Bowers. And then Justice Scalia in his dissent said, you know, the next thing is going to be you're going to find a constitutional right to same-sex marriage. And then Justice Kennedy, so it's interesting to see the progression here of Justice Kennedy. It has not been especially clear about the constitutional doctrine, constitutional framework there for the right. So.
All right. Any closing thoughts? No?
But I think, you know, one thing I suppose, favorability of the court, you know, for those who follow, after the Supreme Court struck down the Civil Rights Act, the Voting Rights Act of 1965, part of it, the favorability rating of the Supreme Court fell below 50% for the first time in history, for those who follow that. It's now back up, I checked, to 56% favorable, 35% unfavorable, which is one of the lowest favorability ratings in history still. However, for any other political body in Washington, a 56% favorability rating would look pretty good. So there are different ways of doing that. Exactly.
Yeah, you don't have to worry about that, unless you follow Eric's advice. All right, well, I'd like to thank our panelists. Thank you all very much. This has been, we have so much more we could discuss, and so to the extent they can hang around, we can discuss with them some more. But that's the formal part of our program, and please do stick around for hors d'oeuvres, and I'll hand it over to Matt to close us out.
Thank you, Professor Shalf. Wanted to make a couple of thank yous. First off, to all of you who came out here. It's really good to see an awful lot of students who we haven't seen before in the crowd today. That's really encouraging. One of the reasons we had this was to really bolster our visibility in the community. We hope that you're excited about these issues. If you are, we want to get your contact information and be in touch. So Will Carson over there in the back, Will's raising his hand right now. If you want to talk to him, he can get you kind of connected with other things that we do. Next, I'd of course like to thank our panelists for coming down here today and coming across town in Professor Segall's case. In particular, Professor Volokh and Dean Shapiro, as you've heard, have been continuous supporters of what we're doing with LSCAP. We appreciate that an awful lot. And Professor Segall, we're looking forward to building a relationship moving forward, given your passion and interest in the cases. And last but not least, this entire event last year was some pizza downstairs in a lecture hall with about 3 other students. As you can see now, we have tablecloths, we have windows, we have quite a bit more food and some beverages, both alcoholic and non. None of that would have happened had it not been for somebody who was not on the board, but who stepped in and really put forward a heroic effort to make this happen, and that's Rachel Myers. Rachel, if you would please come up. We do have a token of our appreciation for everything that you did that Ryan Foley is going to dramatically bring up from the back of the But Rachel came to us after having run the Laws Conference last year. She did a great job there, and once again, just really was a one-woman team who really made this happen. So another round of applause for Rachel, please.